and for selling meal tickets. And I'll have Kevin come up to introduce the speaker.
So today we're honored to have Stephen Buckley with us. He is the son of Albany Rotarian Tom. And he's going to talk to us today about some estate planning and elder law issues or ideas. And hopefully we can each take one or two ideas home with us to keep in mind. So, floor is yours.
Thank you. So I'm just going to pass around some slides if I don't know if people want to take notes or maybe they can see it better.
Where's your dad today?
I believe he's in Massachusetts with my grandmother. So if I need to go to the next slide, I'll just let you know.
Yeah.
All right. So good morning, good afternoon. My name's Stephen Buckley. I'm an estate and elder law attorney. I have an office down in Menands. I'm just going to go over a few basic things today. Next slide, please. I'm going to cover...
We were on the last one, not the first one. There we go.
There we go. What exactly a last will and testament does, what you can and can't gift with it. I'm going to cover how to pick an executor of your estate, what is an executor, how to pick an executor. Also, I'm going to cover healthcare proxy and living will very quickly. They're two documents, are they one document, what do they do? I'm going to talk about the power of attorney. Power of attorney is the most important estate planning document. I don't care if you don't have a will, if you don't have a healthcare proxy, if you don't have a trust, power of attorney is a document that everybody needs to have. I'm going to very briefly cover nursing home trusts in under 2 minutes. And I'm also going to talk about some factual circumstances when it's a good idea to see an estate planning attorney. Next slide, please. So your last will and testament does essentially two things. I brought mine here today. This is my will. It does two things. It says I give my entire estate to my spouse. So we're talking about giving away assets. And then the second thing, it says I appoint my spouse to be my executor. So we're talking about two separate things here. Where does your stuff go? And who is in charge of transferring your stuff to your beneficiaries? The last will and testament only deals with estate assets. Can we go to the next slide, please? And so that brings up the question, what is an estate asset? An estate asset is any asset that you own when you pass away that you individually own. So if there's a bank account and just your name is on it, there's a real estate, if you have a deed to a house and just your name's on it, then it's an estate asset and your will controls where it goes. Most people want to avoid the probate process. If you've ever been an executor of an estate before, you've been through it, you know all the reasons why you want to avoid it. So when I meet with a couple, husband and wife, one of the first things I do is I go through all the different accounts that they have to make sure that if there's bank accounts, both the husband and wife's name is on that account. If there's any life insurance policies, there's a beneficiary on that life insurance policy, so that when the spouse passes away, the will doesn't come into play at all. All their property automatically, upon somebody's death, transfers to the surviving spouse. So you don't have to go through the probate proceeding. And that's typically one goal that my clients are interested in achieving. But you still need a last will and testament, and I'll give you a few reasons why. The first is, do we have any local bankers here? Nobody that works for a bank? So about maybe four or five times a year, I have to do what's called crisis planning. Crisis planning basically means mom or dad did no estate planning, and now they're in St. Peter's or Albany Med, and they're going to pass away in the next 7 to 10 days. So when that happens, we have a responsible family member running around to various financial institutions, changing account names in order to avoid probate. So I'm not going to say the institution, but I had a woman who was in St. Peter's. There was Everything else was jointly owned except for one account with a local bank with about $80,000 in it. The son went to the local bank, got the beneficiary designation form, brought it back to his mother in St. Peter's. They filled it out, she signed it, they give it back to Citizens, and 3 days later, mom passed away. So, mom passed away, the son a week later brings a death certificate to the bank and tries to collect the bank account. Well, the banker gave the son the wrong form, and now mom's not alive, so she can't sign it. So now we have to go through probate for this $180,000 account. These things happen. I also had a little bit more of an absurd situation was with a financial institution. I'm not sure what it was. I'll just use Morgan Stanley as an example. Nobody works for Morgan Stanley here, right? All right. I had a case where a client actually filled out the beneficiary designation form for a brokerage account. It was an account with $300,000 in it. And he gave it to his Morgan Stanley advisor, and they sent it to their home operation, wherever Morgan Stanley is based out of. Morgan Stanley had a copy of the beneficiary designation form, but did not have the original, and therefore they would not honor a copy of the beneficiary designation form. And that was a little bit of a trickier situation because the beneficiary was his girlfriend at the time, a girlfriend of 20 years, basically a wife. But because she wasn't listed, I think the last two beneficiaries that were listed were his son and daughter from a previous relationship. So it took about 3 months to straighten out. But these things happen, and you never know if they're going to happen. So we still have a will, just in case. Next slide, please. How to choose your executor. Most people come in and they pick their oldest child. That's not the best way to choose an executor. You want to pick somebody who can balance a checkbook, somebody who's responsible. Now, you know your kids. Is that your oldest child? Maybe it is, maybe it's not. But that's who you want to pick. A person who's financially responsible, that when I call them up to sign paperwork, they can get to my office within 2 or 3 days. That's capable of finding a notary public and signing in front of a notary. I don't want somebody who's going to tell me they've been trying to find a notary for 4 weeks. I want somebody who can go to the bank or go to the town hall, a little bit of a self-starter that can take care of this stuff in a timely manner. And preferably somebody that's local. A lot of times we're talking about real estate. If you own a house and you pass away, your house is sitting there. You want somebody who can secure the house. If there's other people that have keys, you want somebody who can meet with a locksmith to change the locks. You want somebody who can stop by the house a couple times a week to make sure the heat is still working, because my next door neighbor will tell you, when you go away for 2 weeks and a pipe burst and you come home, there's a lot of damage. It doesn't have to be somebody local, but it's usually easier that way. And basically how it works is you would pick your spouse to be the executor, and then as a contingent executor, you would pick one of your children, usually one of the more responsible ones, as I just mentioned. All right, next slide, please. Healthcare proxies and living wills. Is it one document? Is it 2 documents? It doesn't really matter. In my office, I draft 2 separate documents. There's one healthcare proxy of Stephen Buckley and a second document, Stephen Buckley's living will. 2 separate documents. Not all lawyers do that. Some can bind the documents, and that's fine. Some call it something different. They'll just say healthcare directive, but it will still contain the language for healthcare proxy and living will. It doesn't really matter if it's 1 document or 2 documents, as long as you understand it does 2 important things. The first is you're appointing the healthcare proxy portion. You're appointing an individual to make decisions for you if you can't make decisions for yourself. So an example of this would be if I fall and hit my head and an ambulance takes me to the ER, and because I was knocked unconscious, I'm unable to make decisions for myself at that point in time. You want to clearly delineate who's going to be able to make those decisions for you. The doctors really want you to have a clear authority to make decisions on behalf of you if you're in a medical situation. The second portion, the living will portion, gives specific instructions to your healthcare proxy regarding end-of-life decision-making. Now, end-of-life decision-making is a very specific issue. This only comes into play when you're suffering from an incurable disease that's reasonably going to result in the end of your life as determined by 2 doctors. So, if you appoint somebody as your healthcare proxy and you fall and break your leg and you go to the hospital, maybe they have to do a surgery on your leg, the healthcare proxy can't make end-of-life decision-making because you're going to recover from a broken leg. It might take a month or 2 or 3 months, but you're going to be up and out and about. Again, if you're diagnosed with stage 4 cancer, then things get a little bit more serious. If I had a client, I think he had pancreatic cancer. This is one of the types where by the time you know you have it, it's already too late. Within 2 or 3 weeks, you're probably going to pass on. And during that time, what happens is you end up being on a lot of drugs, a lot of medication. Your body starts to shut down, and the healthcare proxy can basically make one of 2 decisions: to keep you alive at all costs, or to withhold artificial nutrition, hydration, and basically pull the plug and let you pass naturally. All right, these are incredibly uncomfortable things to talk about. People don't like to talk about these things, but it's important to let your healthcare proxy know, because in these situations where we're talking about end-of-life decision-making, it's very stressful for your family, because you're usually appointing your spouse or sometimes a child, and it's very difficult for individuals to make end-of-life decision care. It's even more difficult if it's ambiguous, if you never discussed exactly what your preference is. So if you take anything away, you should have had that conversation, and believe me, you're going to do your family a big favor by doing that. And then I just wanted to mention there's essentially 2 options here. Keep you alive at all costs, artificial nutrition, hydration, on a respirator, that's a choice, or to let you pass naturally and withhold those 3 things. And I would say probably 95% of my clients choose to pass naturally, but it's your choice. There's no right or wrong answer. I've had couples that have different opinions on that, and that's fine. It's not for me to decide. It's a personal decision, and you should talk it out. Next slide, please. Estate planning isn't the most interesting topic. Do you have a question?
Yeah, on the, I've got both a healthcare proxy and a living will. And hospital is telling me that neither one of them are any good. I gotta have another form that I have to fill out, which I'm gonna do, but I've always heard, okay, so you have a living will and healthcare proxy, and you're good to go. I don't understand what this additional document is.
Sure. So for our Facebook listeners, I'm just going to repeat the question. The question is, if you have a healthcare proxy and power of attorney and you go to the hospital, why does the hospital make you fill out additional paperwork? You're probably talking about a MULST form. And basically, because we're talking about end-of-life care, the hospital wants to make sure they clearly understand what you want to happen under specific circumstances. So even though you have a healthcare proxy and power of attorney, if you go to the hospital and you have to go through a surgery, or if you're getting any sort of treatment, they'll usually make you fill out a separate form at the hospital. And that's always going to be the case. The healthcare proxy and living will, if you can't fill out that form for yourself, your healthcare proxy would be able to fill out that form for you. So you shouldn't be surprised if you go to the hospital and they make you fill out the MULST form, but you should know that if you were unable to fill out that form because you hit your head and now you're unconscious in a coma, the healthcare proxy document that you did sign previously would allow one of your family members to complete that paperwork on your behalf.
What was the acronym you used, the what form?
MOLST. It's I don't know what it stands for off the top of my head, but the MOLST form is it's
Spell it.
MOLST, MOLST. It's a standard form that most hospitals in New York State have you complete before any major surgery.
Well, that's just their life, though.
That's right.
Why else?
What else, yeah. Is it not the case that relatives can supersede what somebody signs in their living will? And it is just a desire to be treated in such a way, but there are cases where relatives overrule what has been put into a healthcare proxy or a living will.
So that is not the case, and if we go to the next slide, we're going to talk about that specific issue. Yes?
Is it good to have a sort of a backup person to the ones that you select for these functions?
So the question is it good to have a backup healthcare proxy? Yes, it is. It isn't. You don't need to have a backup as long as you pick one person that is younger than you. So if you're picking an executor or a healthcare proxy, we're going to talk about the power of attorney in a few minutes, you don't have to pick up a backup. Usually you do. Usually you would pick your spouse and then somebody that's younger, whether it's a child or a friend or a neighbor. Some people only have one particular person in mind, and as long as that person is younger than them, as long as the person that they pick is likely to outlive my clients, then I'm not too worried about it. So it's a good idea to have a backup, but it's not necessary as long as the person you're picking is younger than you.
I was just gonna say, the most form is a medical order for life-sustaining treatment.
Right, MOLST.
So it's pretty much in the hospital, so even your healthcare proxy can do it if you can't. If you're not responsive to make that decision, but it's a form that allows CPR or no CPR, intubation or no intubation.
Put my phone up there, it has the acronym.
Thank you. So, the Family Health Care Decision Act was passed, I think, back in 2010. And if you don't sign a healthcare proxy, then there's a statute in New York that presumes certain family members have the ability to make decisions on your behalf. And this is in order of priority here. So if you don't sign a healthcare proxy or a living will, your spouse can make decisions for you, or if your spouse is not alive or unable to make decisions, your adult child is able to make decisions for you. But again, there can't be any ambiguity as to what your decision is. You still need to clearly express to your family member, your spouse, your adult children, what exactly your wishes are. And I'll go back to your question here. Your family members can't go against your wishes. The healthcare proxy and living will supersedes the statute. And
I'm not
when
worried,
you
my kids are ready to do me in.
But this is an important point because, unlike some other estate planning documents, making end-of-life decision-making is not easy. And a lot of times if you pick a child to make those decisions for you, you don't know if they're going to be able to under the circumstances because it's really difficult. So when you're picking a spouse or a child to make those decisions for you, you want to make sure that they're going to be able to. I found that if you have a child that's a nurse, nurses make the best healthcare proxies because they know how to speak to doctors, they understand what you're going through, they understand hospital organization, and they've probably dealt with some of these difficult situations, not maybe for their own family members, but for patients that they've dealt with in the past. So my point here is it's a good idea to still sign a healthcare proxy and living will, so there's no ambiguity, so that if you have 2 or 3 children and they're both arguing over, what to do with you while you're in the hospital, you want to make sure there's no ambiguity. This is one of those things in life where there's no room for error. Next slide, please. power of attorney form.
Steve, just the thing there, where you have brother or sister,
Mhm.
in a situation in our family, there are